Hi, this is Paula Kelly with NC Guardian and Care Management. We are going to talk today about identifying supporters and building supported decision-making teams to protect solo agers and other vulnerable adults from exploitation, abuse, and unnecessary court intervention. We're going to talk a little bit about guardianship and how to avoid guardianship. And, I just wanted to point out that there are a lot of people out there looking to provide services for seniors and other vulnerable adults, and they're not all good. So we're going to talk about properly vetting those services and having supporters in place to help you do that as you age. I'm going to make some recommendations for who would be appropriate for being on a supported decision-making team. We'll talk about what it means to have a court-appointed guardian versus at-will fee-for-service. That means hiring somebody to be your fiduciary or your decision-maker. We'll do an explanation of what healthcare agency means, what it means to have a healthcare power of attorney. Some national standards for best practice for decision makers, and how we work here at NC Guardian and Care Management. So levels of support, I like to say that everyone has a supported decision-making team. Some are formal and some are very informal. My personal supported decision-making team are people like my husband and my parents and my kids. I call them when I'm making a big decision, and they give me advice. And sometimes I listen to their advice and sometimes I don't. That is a supported decision-making team. For vulnerable individuals, maybe that means they're aging and are having some cognitive issues, or they have maybe a developmental disability. Anyone who's vulnerable, or an individual who is paying for support. If you are compensating your fiduciary, and that means you're paying someone to be a decision maker for you, I believe that the best situation to set up for yourself is to have a formal supported decision-making team that identifies how your decision makers will have oversight of each other, so that you're protected from one of those people, taking advantage of the relationship. So if you're hiring people to do that, that's a fee-for-service relationship. And guardianship, of course, is the most intrusive. That guardianship is when a clerk of courts decides that you don't have the capacity to choose who your decision makers will be, and they appoint someone to be your decision maker. So what happens when you're admitted to a hospital or an incident occurs that a decision maker needs to be identified and you are not able to make or communicate your own decisions? Sometimes that's, a hospitalization after a car accident and someone's not conscious, or a surgery is necessary and you're not able to make or communicate that decision. So a facility will use the following people in your life to identify a decision maker. And this is according to the North Carolina general statutes. So the first person is your spouse. If you don't have a spouse, then your parents or your adult children become your decision maker. If those aren't available, then the majority of your adult siblings. And if those people are not available, then the way the law is written is that any individual with an established relationship with you that is acting in good faith can be a decision maker for the system. So that might be a neighbor who accompanies you to the doctors, who can say to the doctor, this is what they wanted, or this is what they've told me that they wanted. The healthcare providers have the ability to decide if that person is acting in good faith, if they know you well enough. The law is kind of vague with that fourth one, but that's the way the law is written. If they can't identify a decision maker, the facility can petition for guardianship. So some of the potential situations when that might come into play are if an individual is hospitalized, they've been maybe living alone, and they've maybe had a stroke or have a broken bone, or some reason why going home alone again is unsafe. If they don't have a decision maker and they don't have a safe discharge plan, that is a pretty common reason for a facility to petition the court to identify a guardian. Sometimes it's when someone's living in a facility, maybe assisted living, and they require more care than the assisted living can provide. They maybe need a skilled nursing center, and there's no decision maker that can help facilitate that transfer from one level of care to another. Sometimes it's a concerned neighbor. Anyone can petition for guardianship. Any concerned person. So sometimes it's a neighbor noticing that there's someone on their street that seems frail, seems unsafe, and they might report that situation, or they might, petition the court and say, we think this person needs to have a guardian appointed. And oftentimes the petitioner is Adult Protective Services, because someone has contacted them to say, we believe this individual is at risk is being exploited or abused, and they need a decision maker put in place. So those are just some potential areas where the court can get involved. I like to tell people what our mission is to get involved with clients before court intervention is necessary. We like to help people identify their supporters, get a supported decision-making team in place so that they never find themselves at a point where court intervention is necessary. The process for guardianship, I think it's important to understand. I get a lot of people that come to me and say, I would like you to be my guardian. And I clarify with them that they don't want me to be their guardian. So the process that takes place is that a clerk of courts, who's an elected official, there's the person that is petitioning for guardianship, the person that is potentially needs a guardian. Everybody sits in a courtroom, and there's a hearing, and the clerk of courts decides whether that person is competent or incompetent, whether they can make their own decisions or whether they need someone to make all of their decisions for them. Like I said, any person can file the petition, can be a concerned neighbor, can be a family member, can be a facility. The process usually includes a multidisciplinary evaluation, meaning the clerk of courts usually will say, I want this person evaluated before I make a decision, maybe by a psychiatrist, or have some other clinical studies done to give them more information about competence. But it isn't part of the law. No part of the law says a multidisciplinary evaluation has to be done, and it isn't always. So that clerk of courts hears all the testimony and makes that decision. If a guardian is appointed, the clerk can limit what the guardian can and can decide for the person, but it's possible that the guardian can make all decisions for that person, meaning decide where they live, how they spend their money, on what clothes. They consent for all medical care. They decide if what's necessary and what isn't. They provide for all comfort and well-being. They make all decisions. Guardianship can take all of your rights away and put those on another person to make decisions for you. It's very intrusive. And why I think that guardianship should be a last resort. The other part of guardianship is that the person doesn't get to say who they want to be their guardian. The clerk of courts decides in the end who is going to be that person's guardian. Typically, typically, the clerk of court tries to identify a family member or a personal contact, somebody who's already known to the person. Sometimes those, people who end up in this situation don't always have family members or personal contacts. So another option for the court is a corporation, a private corporation. NC Guardian and Care Management is a corporation who can provide guardianship. The law says that in order to be a guardian, you have to, if you're a corporation, you have to identify that you're going to do that in your articles of incorporation. You have to be at least 18 years old and you have to not be a felon. There is really no specific additional qualifications or requirement for education or competency for a guardian, a corporate guardian, unless you are a corporation that works with a public agency. Unless I contract with the Department of Social Services to provide guardianship, there's no additional training or education or qualifications. So kind of anyone can do this, which I think is scary. The third option for the court to appoint is a disinterested public agent, and here that is the Department of Social Services. When the Department of Social Services is appointed, they contract with a nonprofit called Hope for the Future locally, and Hope for the Future provides guardianship services. There are some additional qualifications required. The law says that they have to attend additional training. It is not specific what that is. So that's, also problematic. In 14 states, national certification and continuing education and other requirements are other education qualifications and backgrounds required to be a guardian. So you can see what states here additional certifications are necessary, and you can see that in North Carolina, no required certification is necessary. There are 7 nationally certified guardians in the state, and NC Guardian and Care Management is one of those. The other nationally certified guardian is the executive director for Hope for the Future here locally. So, there are other private corporations providing guardianship. It's my opinion, and that's why we're nationally certified, that a national certification should be required. But it's not yet. So our laws in North Carolina had not been updated for many, many years. There's a group out of UNCA that has been working for many years to update them. The guardianship rights law was finally passed in the fall of last year and went into effect in January of 2024. And there are some great things about the updates to this law. It does protect a person's human and civil rights, and it makes it so that when they go to court, the guardian ad litem who's assigned to them has to communicate what their rights are, has to make sure that they're aware that they can request a jury trial, some other things, but it in some ways it does add some protections for people for whom guardianship is a possibility. In some ways, I think, though, it has exposed those people to some other areas where they could be exploited, in that part of the law requires a less restrictive alternative to guardianship be attempted before the clerk of courts will grant guardianship or will, make it necessary for someone to have a guardian. Those less restrictive measures include care management, or having a joint bank account, or having different power of attorneys in place, like a healthcare power of attorney or a financial power of attorney. The problem, a lot of attorneys that I've talked to and people who work in this area will say that a lot of times guardianship cases end up in the courts because a power of attorney has exploited or abused that person. So these supportive decision-making these less restrictive alternatives, although they can be very helpful for people, if someone is already vulnerable, if they just name someone to be financial and healthcare power of attorney they don't know very well, or that when there's no oversight, they can be exploited because there's no oversight of that relationship. Someone who is already maybe doesn't fully understand the relationship they're getting into when they sign a power of attorney document, then signs over the ability to make decisions for them and isn't able to understand what it is they're assigning that person, and is doing so without any court oversight at all. When a clerk of courts appoints a guardian, they require some oversight. The court is providing the oversight, in that a guardian has to give a report back to the court at 6 months and then annually to talk about how they're serving this person, what they're doing to provide housing, how they're making sure the person is safe. That kind of information is in the court. If someone is doing power of attorney documents, or identifying payees, or having maybe a neighbor do a joint bank account for them, doing some of these less restrictive alternatives, then there's no court oversight. The courts are not involved, and that person is just they're having the same type of support that a guardian can provide without the court making sure that they're protected. I've alluded to some of the problems I think that can occur with that, but when there are no requirements for who can do this, no specific qualifications or licensure or certification, no specific requirements for who can enter into one of these relationships with a person. There's lots of room for unqualified people to be doing it. It can be expensive. There are no parameters for what we charge. And I say this because I'm one of these corporations. And I can hang my shingle and say, I'm going to be a guardian or a healthcare power of attorney. And there's no one to say, let me see what your credentials are. And I can charge whatever I want. There's no parameters for what I charge. There's little oversight with the court, but there's no oversight for a power of attorney. There's no one looking over my shoulder to make sure I'm doing a good job. And as I mentioned, our state laws are pretty dated. There's no reference to them on national standards or how best to do this. So when I take on a new client, I talk to them about building a supported decision-making team, because I'm asking for oversight. I want there to be, if I'm helping you make healthcare decisions and I'm invoicing you for my time, I want there to be someone who is your supporter for financial matters that can say, let us look at this NC Guardian and care management invoice and make sure that things are appropriate, that they're doing a good job for you, that you're not overpaying for a service that you don't need. So a supported decision-making team means that you identify trusted advisors who can help you make and communicate decisions if at some point you need assistance. Your supported decision-making team might be one person who's paid, and one person or two people that are known to you, maybe their family, maybe their neighbors. They don't all the people on your team don't have to be compensated, and not everyone needs a compensated fiduciary. Not everyone needs to hire a healthcare power of attorney. Some people can build their supported decision-making team with people that are already known to them and they trust. Another thing I want to mention is that individuals retain their right to make decisions for themselves until a time is necessary for your healthcare power of attorney to start making decisions for you, and a medical person makes that decision. So when someone hires me to work with them, I work with them, my relationship with them is as an advisor, as an advocate. I meet them, I learn about their health care. I'm available to them to help answer questions or to give my advice, but I don't make decisions for them until the time when a doctor says this person is not able to make decisions for themselves. And you, as a decision maker, will start to make and communicate those decisions for them. And I have already built a relationship with you to know what those decisions are, to know what you would have wanted. I like to encourage clients to have, I like 3-person supported decision-making teams. I like 1 person to be healthcare, 1 to be legal, and 1 to be financial. And when we form a supported decision-making team, we also identify the way we'll have oversight of each other and how often we'll interface with each other, how often we'll report back to each other, and what each person on that team will be doing. I think this is the best to develop a supported decision-making team and identify what each member will be doing, how we'll have oversight, and how often we'll interact is the key to protecting people from being exploited from any 1 person on the team, and also protecting you from court intervention, because whatever comes up, in the future, you have identified the supporters to make and communicate the decisions you would have wanted to make if you were able to do it on your own. So a supported decision-making agreement is just a formal plan that identifies your supporters, what we each will do, how we'll have oversight of each other, and a way to handle situations when your supporters don't agree. I like to add that to my agreements, because that could come up in the future, and I think it's important. I think planning ahead is important, no matter what. So having a plan keeps us out of trouble. Choosing your supporters, if for healthcare, I think it's important that your healthcare supporter has some knowledge and experience in healthcare, so that they're able to help you discuss medical needs. I like to talk to people about what their specific preferences, needs, and goals are for aging. Do you want to age in place? Are there facilities that you'd like to look at to consider when there's a time for a higher level of care, so that we've already identified what facilities you like? When I meet with someone, I see what's already in place, and what's working, what do we need to do better? For clients that I work with, I like to ask them to do a life plan, so that I have some guidance when I'm making decisions on your behalf. I'm really not making the decisions. I'm just looking to see what your decisions were, and I'm supporting those decisions and advocating for you to make sure you get the care you wanted. In terms of finances, NCGCM doesn't do anything other than personal and healthcare. So we don't do anything with finances or legal matters. We are not, we can't be your financial POA. We can make some suggestions. If you don't have someone doing that, we can make suggestions for options in town that can help you with financial and legal matters. But you want somebody who is qualified to help you with your finances, someone who can help you organize your bills, balance your accounts, planning for how you'll make and communicate financial decisions as you age. How will you pay your bills if you start to have some cognitive issues? Or, what happens if there's an event, a car accident, a stroke, something that, you can't make or communicate your financial decisions tomorrow. How will you pay your bills? So getting that person lined up is important. And I think attorneys, especially attorneys who work with elder planning, are good people to have on supported decision-making teams, to help provide some oversight, make sure everyone's doing what they need to be doing and the person is protected. But as I said, your supported decision-making team does not have to be all professionals. it might be children that don't live close to here, or it might be neighbors or good friends. The most important thing is that these are trusted individuals. And if you're hiring professionals, it's important to make sure that they have the right insurance in place, that they're bonded, and that there's some oversight of each other just to protect you. So since I specifically function as a healthcare power of attorney agent, I just wanted to talk briefly about what that means. I talked a little bit about it already, but that's a legal document that specifies who you want to make and communicate decisions for you if you can't in the future. You want that person to know what your wishes are. So you will be, once you identify who your healthcare power of attorney is, then you'll want to have many conversations with that person about what it is that you want them to do, what decisions you would make if it were you making the decisions. So that when the time comes, if they have to make and communicate decisions for you, they're not needing to, decide on their own. They're only supporting what you wanted. It's also important to understand when that healthcare power of attorney comes into play, because it is a doctor who decides that the person no longer has the capacity to make their decisions. And in an emergency, even though let's say you've identified our company to be your healthcare power of attorney, and there isn't something happens to you at home, I can't call EMS, or I can't even show up and say, I'm their healthcare power of attorney and you have to do what I say, because nobody's identified that you aren't competent to make your decisions, that you don't have the capacity. So it's important if you have a DNR status, or if there are certain things that you want to identify, you would want or wouldn't want, that you talk to your doctor about a MOST form, which is a medical order for scope of treatment. It's signed by your provider. It tells them what life-sustaining treatment you want or don't want. And that's important to have. I like my clients to have those on the refrigerators. EMS knows to look at your refrigerator for a MOST form. So if you want those decisions front and center for medical professionals, the EMS, to know before they transport you to a hospital, it's important to have that. Because even having a healthcare power of attorney doesn't protect those decisions in an emergency situation. So formal support, you can, the forms to identify your healthcare power of attorney or your financial power of attorney. I talked a little bit about a compensated fiduciary. That is somebody that you pay to make and communicate decisions on your behalf. A fiduciary is somebody who is bound to make decisions that are in your best interest, putting your best interest above their own. So, and a compensated fiduciary means you're paying them to do that. There are lots of at-will fee-for-service relationships that you can hire people to take care of you. Basically, there are companion caregivers. There is home health. I mean, even hiring service providers to clean your house or do your landscaping. Those are all ways that you can support yourself to be living on your own. So I include that here. A supported decision-making team and agreement, I think, are the best formal support, as long as you're able to understand those relationships. For a financial compensated fiduciary, a trustee, having a trust and a trustee to make financial decisions for you is often a good choice for people. It depends on your assets and who will do that. Some banks will do that. It depends on your assets. There are daily money management services that can be another option for people. And again, guardianship, a court-appointed guardian is the formal support that I think is it is necessary, certainly for some people, but it absolutely should be a last resort. There are some best practice concepts for people that are making decisions for another person. Substituted judgment means If at some time you can't make decisions on your own and I were making the decision for you, I would be able to say, I know this is what that person wanted. We've talked about it. They've written it down. I have some firsthand knowledge that this is what they want. So I'm substituting my judgment for theirs. Best interest means I don't know what that person would have wanted. We haven't ever talked about this, but I'm gonna talk to the professionals involved and make a decision based on what's in their best interest. Client-centered planning means I don't make decisions, even if a doctor says that this person is not capable of making their own decisions. I try to make the decision with you. There are times when I work with a lot of people with dementia, and maybe there are times in the day when they're more able to participate in decision making than others. Maybe the mornings they're less confused and we're able to have a conversation about something that's happening with them or a decision that needs to be made. And by later in the afternoon, they're having more cognitive problems and they wouldn't be able to make that decision with me. But client-centered planning means if you are capable of helping to make the decision, then we make it together. We've talked about supported decision-making. That just means, there are people who are perfectly capable of taking care of themselves. They just need some help. And they're identifying their helpers, their supporters. They're making it formal to decide who's going to be helping them, down the road. Honoring fiduciary duty. I mentioned that my fiduciary duty to my clients is to put their needs above my own, to not profit off decisions that I make, to make, what's best for them has to be the decision I make, regardless of how it affects me. And honoring that duty is very important to me, personally. Allowing the same degree of error to the same extent of anyone else, I think that's very important in that, everyone makes mistakes. And people who have a decision maker making decisions for them, they get to make mistakes too. I sometimes spend too much money or drink too much wine, and that doesn't mean I should be, that nobody judges me for it. This just happens. Somebody who has a guardian or has a power of attorney making decisions for them, they get to make mistakes too. There needs to not be any I don't know, they need to be allowed the same degree of error that we all are. And balancing personal autonomy and protection and safety, that just means, trying to make sure you're able to live as independently as you are able, and that there are some risks that there is people are allowed to make decisions that I wouldn't necessarily agree with. They are allowed to put themselves at a little bit of risk if they understand that is understand what they're doing. Like, I had a client today who she has caregivers assigned that come to the house, companion caregivers, in the evenings to help her get ready for bed and help her do some personal care. She didn't like the person that was on the schedule today, and she wants to cancel them. I know that she's safer at home when she's getting ready for bed with the companion caregivers, but she has the autonomy, the agency to make those decisions on her own. She understands that she's safer when they're there, and she doesn't want somebody coming tonight, and she gets to make that decision. So I'm doing my best to balance her autonomy and her protection and safety. And the last one is no overstepping. People get to make their decisions, and I am here as necessitated by what they're able to do, both mentally and physically. So I'm not allowed to overstep and force my will on someone else. Those are the best practices, and that's why I think it's necessary for all guardians to be nationally certified. Guardians that are certified through the national agency are held accountable to the best practice standards from the national organization, and educated on the best way to do this. So our process at NC Guardian and Care Management, just quickly, is that we meet people initially to do just a meet and greet, see what your needs are and see what if what we do and what you need is a good fit. And then we set up an assessment. We talk to you about what's working, what needs improvement. We talk about emergency plans. We, at that point, identify supporters. Like I said, I like a healthcare, a financial, and a legal, but that doesn't have to be how it is. Everybody's supported decision-making team is different. Everybody's care plan is different. We write a care plan that says what we're going to be doing, who's going to be doing it, and when we'll do it. So for some of our clients, that means we are attending doctor's appointments with them on a regular basis. For some of them, we're calling them to check and make sure they're okay. For some of them, we are just on standby in case at some point they need a healthcare decision maker. We identify what it is we'll be doing, who will be doing it for them, and when we'll see them again or how often we'll be making contact with them. Minimally, if somebody is a client of ours, we will see them minimally quarterly. We'll see them for an assessment, and then every 3 months we touch base with them again to make sure they still don't need anything from us, or if we need to change our plan of care. And on those quarterly visits, we update our plan of care and we talk about the 4 M's of healthy aging. We talk about any medication changes that have happened or new providers, new diagnoses. So medications, mentation, any cognitive problems or issues that we need to be aware of or plan for. Mobility, any changes in your mobility. Is there a fall risk? Are there things that we need to get in place because there's a change? And what matters to you? So, or is your plan still to age in place? Or do you want to make any changes to your advanced directives? Is there anyone else that's new that's involved in your care that we need to be aware of? All of those are the 4 M's that we look at when we see you quarterly. And then these are just some services that we provide. Like I said, everybody's care plan is different. And for some people, we see them weekly. For some people, we see them more than once a week. And for some people, we see them quarterly. We do a wide variety of things, all in relation to healthcare advocacy and just kind of supporting a person while we support their preferences, needs, and goals. So we can set up service providers. We can do home safety assessments and get DME ordered, durable medical equipment. I talked medically too much. We can attend medical appointments. We can serve as a healthcare power of attorney. For some of our clients, we're not the healthcare power of attorney. For some clients, they maybe have a healthcare power of attorney who's a child or a family or friend. Maybe they don't live here and they want, and our client wants somebody local who can be an emergency contact and who can, be their voice, make sure their wishes are respected, but we aren't necessarily named as a healthcare power of attorney. We can make referrals or give you some people to contact if you need legal or financial support. We can visit your home and do cognitive assessments and functional screenings. Our staff is familiar with dementia care and cognitive screenings. For some clients, we can do concierge type services in that, we can help you vet and supervise home care or things for your home sometimes we have some clients that are not comfortable being in their home if they have a plumber coming. So somebody can help vet and supervise, make sure that plumber has the appropriate insurance and bonding. And then, if you don't want to be there alone, we can make sure somebody's there with you while there's a service provider in the home. We can evaluate facilities if there's a different level of care that's necessary. We can help evaluate facilities and then do admission paperwork and help streamline that process. We have an electronic medical record, so if you have relationships with extended family members, they can actually log into our medical record system and be able to read notes to know how you're doing. They could have, they can contact our staff to keep that line of communication open. Sometimes that's a difficult thing when someone's admitted to a hospital, there's lots going on. It's hard to catch a doctor. Family that's far away might be struggling with, how they can help or what they need to do. And having a healthcare advocate can be, a really great way to get everybody the right information and kind of have a one person that the medical team can communicate with to make sure that everybody is in the know. And just generally be an advocate for our clients. Our healthcare advocates have experience working in healthcare. Most of them are nurses with lots of experience in healthcare. This is a bachelor's degree in nursing, social work, psychology, gerontology, experience in the hospital, able to speak this language, but also with a heart for serving vulnerable people. They're a neat group of people, but that's every client is assigned to a specific advocate who's kind of their person. And then if they need something and that advocate, that particular person isn't available, there are other advocates who have access to the medical records who can see what their wishes are so that any of us who are available can help serve an immediate need. And this is Emily is our office manager, and she is available if you want to schedule a meeting in your home. We do our first, our meet and greet, kind of get to know you, is complimentary, and we're happy to do that to see if this is a good fit. And you can contact her at the office or by email. Our website is the next ncgcm.net. And I just included this consumerfinance.gov because it's a great website. If you have a neighbor, a friend, a non-compensated fiduciary, someone who you're not paying to be your financial power of attorney, consumerfinance.gov has great information about how to set that up with someone and some information for that person to understand what the requirements are. There are some requirements. There are requirements such as record keeping and keeping accounts separate. So it's good information for lay people who want to serve in that capacity for you. I think that's it. And with the election coming up, I just think this is funny. And so I like to include it at the end. And that's all. Thank you.